Thank you for the invitation to just give a brief presentation. I'm going to do it in two parts. One is to talk about what I think an application, what plans should present, and secondly open it up to everyone for anyone that might want to ask any questions of us about complying development, about development applications, whatever might come about that might be relevant to the building certification area. The question was asked to me, what do I see as what should the plans present to us? What do we expect to see? Had a little bit of a think about it, and I adapted a definition. The words aren't mine. I've adapted it from this definition. Maybe someone can tell me what the definition is after we just go through it briefly. It's an explanation and an instruction for the preparation and implementation of the development, including a list of what must be done and how the owner and designer wants it done. Anyone got a bit of an idea what it might have been adapted from? No, hit it pretty well, I think. The word's recipe. What I think a plan and an application is, it's a recipe to get the development done. Not just necessarily built, but to get the whole thing done, to get through the approval process, to show what everyone wants, or what the designer wants, or what the owner wants, so the builder, the cook, can come along and put it in place and get the end product. The ingredients are what I've listed there as what I've see they are in particular for complying development. You got the state environmental planning policies that lay down the rules of what you want to do. There's also a couple of councils that do also have complying development, which is not well known, but councils like Sutherland have got their own complying development in a zone where complying development under the housing code is not permissible. It's in an E4 zone, and allows you to do a variety of types of development and not types of development you might expect to see. For instance, you can do a garage under the state environmental planning policy. You can do a carport under the council LEP, but for some reason garages aren't ancillary development. It's not foolproof. It's just the way the council introduced it at the time, and have no interest at the moment to extend or modify the original documents. But just be aware that, at least in Sutherland Shire, you might have another opportunity if you haven't got the right zoning. Why I've listed those there as an ingredient is that I believe a plan or an application should include how you've designed it, how you've addressed each of the standards, each of the development standards in each of the documents. There's a whole heap of them. Some of them aren't relevant, but the inclusion of a table in the standard and how you've complied with those standards is, I think, a good way both for myself to be able to assess how you've done it and for you to tell me how you've come to the conclusions that it does comply. Because at the end of the day, if it doesn't comply, I can't do my job for you. So I need to understand how you've developed what you want to do and how you've made it comply with the standards. Then we've got a whole heap of regulations that come into play. The regulations tell us a lot of things that have to be included on plans. And that's an extract of a part of the Environmental Planning and Assessment Act. You might think that councils, for one part of it, and certifiers ask for a lot of information. But we ask for a lot of information because the regulations actually lay down what has to be included in plans and how it has to be included in plans, to what scale it has to be included in the plans. It's called Schedule 1 of the Environmental Planning and Assessment Regulation. You probably hate reading it, but it's on the back of most certifiers' application forms, and it also forms part of information brochures that councils hand out as well. There's different requirements for DAs as compared to complying development, but essentially it's in this Schedule 1 at the back of the Environmental Planning and Assessment Act. You can view that online through the New South Wales legislation website. I'd recommend everyone to go there, particularly for the state environmental planning policies, and for that matter you can also access all the local environmental plans of all the council areas. You can find out all the development standards, the zonings, flooding, a whole heap of things. So I'd recommend you going to that website, as well as the New South Wales Planning Portal, where you can get site-specific information, again, zonings and all that sort of thing. Better than looking at the council LEPs and trying to find a site on a LEP map that's got a little line showing a street in there. You just can't pick up anything. To some extent, they're a very outdated document. They need to be able to be more readily used on a computer. Other things I've got there are the obvious things. The Building Code of Australia. You need to look at that. You need to look at the Australian standards to some extent, and to the credit of the BDAA, there's packages that they've put together with Standards Australia or SAI Global. I would recommend, if you don't have access to those standards at the moment, that you speak to probably David and Michael over here to arrange access. All the standards that are available in the Building Code of Australia are able to be viewed and accessed by BDA members at a price and on an annual charge, and you get all the information that you need to look at how you're going to comply with the Building Code of Australia, which I should mention now is up for renewal. It's a 3-year process. There is a new Building Code of Australia coming out on the 1st of May. Comes out the 1st of May every 3 years. Applications for complying development or construction certificates that are lodged on or after the 1st of May will be subject to the new Building Code of Australia. If you've gone through a whole process at the moment and you're based a lot of your decisions based on the current Building Code of Australia, make sure you lodge your application, your construction certificate or complying development certificate with your council or certifier before the 1st of May, because after that the whole game changes. You're subject to the new BCA. Keep that in mind on a regular basis, and if you're entering into a contract to do a design now, and it's going to be a DA, forget about the current BCA because you won't make it. You'll need to go and have a look at the BCA 2019 to do your design too. As I said, comes in for all construction certificates and complying development certificate applications after the 1st of May. Other documentation we need to see with complying development and/or DAs, but generally complying development is this list. 10.7 planning certificate. There's a couple of planning certificates. One's totally useless. It's a 10.72 planning certificate, and then they've got complying development after it. Don't touch it. Same price as the rest, but you get 1/5 of the information and it's useless. So make sure if you're going to apply, when you apply for a 10.7 planning certificate, you get the normal 10.72 planning certificate. There are instances where you will need to do a 10.725, excuse these numbers, but that provides a bit more information about aircraft noise, flooding in some cases. So it's very important to get hold of that one if the first one tells you you've got some issues. if you don't know whether you've got any issues, one, read the certificate. I think there's a lot of people that probably don't read the certificates and leave it up to the certifier, and the certifier comes along and says, sorry, you can't do complying development on that site because of this, this and this. And it's written on page 5. So very important to read it. Shouldn't get that far if we're doing a quote for you to actually put a halt to the whole thing, because you should have read that certificate, and you should get it early on for that same reason. You might be wasting your time trying to comply with one of these documents when you should be actually looking at the council DCP.
Jeff, I make it a sort of don't worry about the lines. I make it a habit to get the 2 and the 5, just as a matter of course. I know it's an extra $80 odd or whatever it is, but you just don't know until you know, sort of thing. So is that your recommendation as well?
It doesn't, well, put it this way, if you're talking about an extra $80 on a $250,000 job, it's a reasonable investment. Yeah.
Sorry.
You're right, that's fine. Where was I? The 10.7 planning certificate. In some cases there needs to be some landscape plans done. They're mainly for DAs. We don't generally ask for a landscape plan for complying development. They're good extras if you want to enhance your presentation, your details or the owner's requirements. Put it in the plan, otherwise it's going to get lost. Stormwater plans, in a lot of cases nowadays, particularly for new dwellings or additions and alterations that are increasing the impervious area on the site, you really do need to get a stormwater or drainage plan done, because the State Environmental Planning Policy has clauses in it that it defers decisions on stormwater back to the council's development control plan. So if you add more than, say, 20 square metres of roof area, you probably find that you're going to have to also include on-site detention. And that's why the certifier is asking for those plans, because it's going to draw in the council's technical specifications and on-site detention. And I haven't got the qualification to do it. You guys haven't got the qualification to do it. It really relies on an engineer applying the particular council standards and to come up with a design for it, otherwise we can't approve it. Just on mentioning the council and the State Environmental Planning Policy deferring to a council DCP, it's pretty rare that the state government defers to the council, but that's one example of it. Another example is the provision of a Roads Act approval for driveways. You need to get a Roads Act approval, which can only come from council, or in the case of classified roads from the RMS, for a driveway from the front boundary to the curb. There's provisions in the state plan that you must have that before a complying development certificate can issue. So if you've got that in mind to go and do it, and that's going to be part of the application, go and apply for that straight away, because that's going to take you anywhere from probably 2 to 4 weeks, something like that, to get that. So don't leave it to lodge the application with the certifier to do the complying development certificate. They'll do the notification, come back with a letter and say, go and apply for this. It just adds time to it, extra month to the process.
Jeff, of course that doesn't apply, does it, for an existing crossover that you're not doing anything?
No, if you're not touching it, it's fine. I've suggested to a number of people just tie your inside driveway to your outside driveway, and then during the job go and apply for new levels to extend the driveway, whether it's getting a wider driveway or something like that. So you can use your brains and use it that way, or if it's just my existing driveway's there, the new one's going to be over there, obviously you can't use that process. But yeah, keep it in mind, if you need a new driveway, go and apply from council early on rather than later. Of course, everyone's in a hurry, of course. Landscape plans, stormwater plans, aircraft noise reports, those that do a lot of designs in the inner west, Botany, Bayside, they're all subject to, oh, not all of them, I shouldn't say that, but a lot of them are subject to aircraft noise, and there are restrictions too in the state environmental planning policy about what contours you can actually have complying development in. In the lower contours you can, the higher ones underneath the flight path you're straight into a DA. But in 15 and 20 I think it is, you can actually do complying development, but you need to get an acoustic report. They'll do some on-site testing and then provide you with specifications on what needs to be done for your walls, floors, roof, ceilings, all that sort of thing, and windows, of course. Other documentation, while I mentioned windows, of course, basics, that comes into play as well. Sydney water tap-in, another one to do early because you might find there's a few restrictions with the location of the sewer. So get in early, $17.66 or something like that. 10 minutes on the computer, and you know whether you're going to be in for any extra costs for peering and casing of the sewer and things like that. So again, it's one of those things, tick it off early rather than later. We always ask for that now as part of the application. Surveys, most designers I deal with go and get a survey done, straight up. Surveys tell you a lot of things. They tell you about floor levels, setbacks, easements. That's always a good one. And they set some boundaries for what you can and can't do about designs. I might just digress back to the 149 certificate, because we did have one job that said everything was okay, and a council came along and said, before we approved it, that it wasn't okay to have complying development on it because it was in a draft heritage conservation area. It didn't show that on the 149 certificate. They modified the 149 certificate before I could approve it. I asked them to modify it to show it. So they modified it and gave me one and said, no, you can't do it. But really it wasn't right what they did. And it wasn't a draft heritage conservation area. So we argued for about a week or two about it. And they were adamant that I couldn't issue a complying development certificate. I just said, well, your planning certificate's wrong. So the client then went off to a couple of environmental lawyers, one of which agreed, unfortunately, with the council, but the other one agreed with me after disagreeing initially. But they came, the environmental lawyer came back and said, yeah, the council's documentation is wrong. So we actually approved and issued the complying development certificate for it, much to the chagrin of the council, but they haven't actually taken this to court. They tended to agree, they were bluffing, in other words. Their difficulty now is that they've issued a 149 certificate, two 149 certificates. One that they modified because they said it was wrong, and then when they modified it, that was wrong. So we're not sure what the client's going to do with the council at the moment, because they've incurred some additional costs to prove the council incorrect. The purpose of mentioning that is that not all council certificates are correct. Read it, and if you've got any doubts, ask your certifier. They might say, oh, I don't know, go and talk to a lawyer, or yeah, I agree with you, and these are the reasons why I agree with you. If we can't convince the council, then you might have to go to a lawyer. What else we got there? Surveys. All the councils are coming up with these contribution plans now. In old terms, there's Section 94 and Section 94A contribution plans. Section 94, or Clause 7.11, were contributions when you're adding additional dwellings onto a site, they'll charge you a fee. It's a maximum fee is $20,000. Minimum fee might be somewhere around about 7 or 8. But the 10.7 planning certificate will tell you, and you get it early on, you'll find out what plan applies, and it's something that should be raised with the applicants very early on, because obviously a fee of $20,000 is a bit of a surprise when they haven't allowed for it. So another reason to get a 149 certificate early, and just check to see whether and what contribution plans apply. I mentioned the 7.11 contribution plan for new dwellings, and in some cases secondary dwellings. In some areas secondary dwellings have to pay contributions, in other areas you don't. But the other one, 7.12, they're contributions that are worked out based on the value of the work. They can't charge both. If they're not doing the 7.11, they might charge the 7.12, and that's valued at 0.5% of the value of the building work between 100,000 and 200,000, and 1% above that. Now, if you're really going to be doing a large job, and it could be a large new home, and the value of the work's going to be over, say, $500,000, the council and the certifier doing the complying development certificate in that particular case will require a cost assessment done and over $500,000 by a quantity surveyor, because that's what the contributions plan of the councils call up. Extra cost. The value of that contribution to is about $5,000, so not a small cost again. Why I ask for it and why certifiers should ask for it is that the complying development certificate will be subject to a condition that the fees be paid. If I put the wrong fee down, or I assess it not in accordance with the contribution plan, they come and talk to me. I hate talking to councils. I used to work for them. I hate talking to them. It's always a problem. So I want to, if it's over 500,000, or it might be $1 million, depending on the particular councils. Some councils are a little bit more practical, others aren't. But if it's over 500,000, very good idea to look and see what's required there, because it will be additional costs, another consultant, another possible delay in the process that you're trying to get through very quickly. And under $500,000, you can expect that there is a cost assessment report generally in some of the contribution plans. We've downloaded those, and we'll send a copy of that to you if you don't lodge it with us. If you come and apply for a fee proposal from us, our fee proposals include commentary on what you're showing us to get the fee proposal. We'll tell you where you're wrong, right or indifferent about your design, and tell you what we'll need for the application to be able to put it through quickly for you. And we'll include one of those cost assessment forms, whether it be a specific one from that particular council or a generic one. So that was that. I hope I've turned this around a couple of times, and I don't know whether I'm going backwards or forwards. Okay. Part 2 is question time about complying development. And I'd like to bring a couple of my guys up here who I didn't advise about this part of it, but if Reece and Mark would stand up, I'd like them to be introduced. And Brad, you didn't get away either, you'll see that there. And there's one other person, Gary. Now, Gary, you may stand up. Gary's a member of the BDA, and we have engaged him to do a lot of our assessments of complying development. He goes around, and also with complying development, you've got to notify neighbours and council. He goes and does that. He does our initial site inspections for us, and does our initial assessments before we actually send out a letter of a list of requirements that might be necessary on that particular application. So Gary does a lot of the assessments. Reece, who's to his left, he's an A3 accredited certifier. He does some applications for complying development, but a lot of the construction certificates. Moving along I reckon they should have numbers in front of them, shouldn't they? I think that, yes. Mark By, he's an A2 certifier, And our newest inmate is Brad Deering. Brad's A4, he's was a local builder in Southern Shire and decided to move on a little bit, and we've had the joy of having him for the last couple of months. He's A4 and on his way to progressing to A2, as is Reese.